all of our technology today. We'd like to welcome you and thank you for joining us for today's session on wills and estate planning. Before we get started, I'm going to wait for Linnell to get the slides up. Oh, well, we'll get and she can catch up with us. So before we get started, a few housekeeping items. We are excited to announce that today's webinar will be accessible to a wider audience. We have ASL interpretation that will be present throughout the entire session. These interpreters will rotate through, ensuring that everyone can follow the content effectively. So if you'd like to access that feature, you're able to simply click on the interpretation button on your Zoom window at the bottom of your screen. Additionally, we are also recording the entire webinar with ASL interpretation. And these recordings will be available later on our YouTube channel for your later viewing. So whether you attend a live session or whether you catch up later, you have the opportunity to engage with the material in a way that suits your needs. Speaking of our YouTube channel, I encourage you to subscribe to our channel so that you can keep up with the latest additions to our video library. We are always looking for suggestions for future webinar topics. If you have any suggestions for topics or speakers, something you'd like to learn about, please feel free to send that to my email, or you can add that in the chat. Please, throughout the session, keep your microphone set to mute. Just a note, if you do experience any issues with bandwidth or audio quality, things seem glitchy, it often helps to disable your camera. If you'd like to start out, you can put your first name and the organization or community that you're from in the chat box, maybe what you're hoping to get out of today's session and how you found out about it. If you have any questions during today's session, please feel free to enter your questions into the chat and we will address them at the end of the presentation. We will also take some additional questions at that time. At the close of today's session, you will see a quick evaluation of today's session pop up in your browser. Please take a moment and complete that survey. It helps us greatly when planning future sessions. One last quick reminder, visit our Facebook page for more information about those upcoming sessions, such as our December session on social isolation and one coming up in January on building circles of care, prevention, support, and healing for sexual violence in later life. You can also check out our website at arrowheadaging.org. So a little bit about us at the Arrowhead Area Agency on Aging. If you can click through the slides, Linnell, catch us up there. The Arrowhead Regional Development Commission is designated by the Minnesota Board on Aging as the Area Agency on Aging and Planning Area under the authority of the Title III of the Older Americans Act. The Arrowhead Area Agency on Aging is committed to helping older adults maintain their highest level of independence. Area agencies on aging are regional organizations that provide supports and services and information for just about everything that older adults could need and their families could need. Minnesota has 7 AAAs across the state that are local connections to older Minnesotans and the community support they need as they might need as they age. The Arrowhead Area Agency on Aging includes the counties of their service area includes the counties of Aiken, Carlton, Cook, Itasca, Koochiching, Lake, and St. Louis County. Now I would like to take a moment to read our Arrowhead Area Agency on Aging land acknowledgement. As we support our mission to help older adults maintain their highest level of independence, we do this while being respectful of the space we are being welcomed into by Indigenous people. We strive to deepen our understanding of the multiple ways in which people see and understand land and acknowledge the Indigenous people who have relationships with this land. We also acknowledge the decades of historical trauma, loss, and grief experienced by Indigenous people. It is our promise to not only recognize these truths, but also take action to show our support of our Indigenous elders, our neighbors and friends, and understand our place within the past, present, and future of this land. We know that this is just one step in recognizing and honoring the sovereignty of tribal nations. So to get to our presentation, we are honored today to be joined by our presenter, Kristin Parendo. Kristin is the lead elder law attorney with Justice North, formerly Legal Aid Services of Northeastern Minnesota. And she specializes in elder law and has for 20 plus years. She graduated from Mitchell Hamlin College of Law in 2001, and Kristin lives in her childhood home of Esko, Minnesota. So Kristin, thank you so much for being with us today, and I'm going to turn things over to you.
Thank you very much, Brenda, and thank you everyone for coming today. And thank you, Linnell, for handling the slides. Let's go to the next slide. Before we start, I just got to say the video showed a picture of my mother-in-law, which was a very nice surprise to see her there. So that was very cool. So I'll have to check out the link and share it with her. So Justice North, who we are and who we serve. So this is our current region that we serve in northeastern Minnesota with our 5 offices. But big news, we are merging with Legal Services of Northwest Minnesota, and that's going to be effective January 1st, 2026. So coming up soon. So that effectively will mean that we will cover the whole top half of Minnesota effectively. So we should be able to help more people. Our name will stay the same, Justice North, and our contact information should stay the same too. So please, if you have anybody in our area, if you're 60 or older, for sure contact us, because we get funding from the Older Americans Act, which allows us to do more things for folks that have more income and asset than would normally qualify for legal services. So please call us. There's no wrong door. If we can't get you the help you need or want, we'll look for the place that can provide it. All right, let's go to the next slide. Okay, so today we're going to talk about wills and estate planning. And why we're going to do that, because, well, I reused the slide, so it's going to help you after your life. But some of the things you could do with trust can help you in your lifetime too. So I kept that in there. It's for anybody. And you're going to learn who would be a good role in different roles for the different documents, who would be a good candidate, and how these legal documents will help you with matters after your death. So let's go to the next slide. So the legal documents we'll talk about today are the transfer and death deed, the different ways you can add beneficiaries on titled personal property like bank accounts and stocks and things like that, and vehicles. We'll talk some about trust and will. Let's go to the next slide. So first, before we get into the documents, let's just talk about a little bit about what advanced planning is. Why do you want to do it? Well, the whole point is to make sure that your goals are satisfied. Everybody's got goals and wishes about their person, about their things, their state. Some of the things you can do in your lifetime, you can make sure those things happen when you can't do them anymore. For example, with the healthcare directive, we're not going to talk about those today, but with the healthcare directive, if you have instructions in there about what happens to your body after you die, you've effectively made a funeral directive. So that can be very useful, of course, after you've died. The other things like wills and trusts and beneficiary designations, those effectively work when you are dead. But trust can also straddle the line as well, like healthcare directives, and we can talk about that more. It's all about keeping control. And if you put it in the right legal document, it gives the authority to your people to make sure that they can do what you want. Let's go to the next slide. I see Darby's question, and we'll get to what makes you go into probate or not. Good question. And advanced planning can help with that, because if your goal is to avoid probate, you want to do some planning so your assets don't have to go through probate. And there's different ways of handling that we'll get into. Some of these documents give you more privacy than others. Sometimes that's important for folks. And it makes it easier for your loved ones to make sure things happen the way you want. And it could make things go easier. It might not, depending on the situation. But the goal is that planning makes it easier. The more planning you have, the less likely there's going to be a fight that will clog things up. There always could be a fight, but if you have a good legal document, it informs the fact finder, like a court, what your intentions are. And that will speed things up if there ever is a fight. And we'll talk about ways that you can avoid fights, avoid a fight from being successful, even if there is a fight. So I don't want to give anything away too soon. So let's go to the next slide. Of course, who should do it? Anybody who's an adult, because we all have wishes and goals. We all have things. So do planning. And it's never too late to do. And you can take it by chunks. So some things you could do right now while you're thinking about other documents. For example, often I tell my clients the different options after I find out about their goal. They say, well, these things could help. But if they're not sure what they want to do yet, there are stopgap measures that will work really good to satisfy some goals while you're figuring it out. For example, doing a transfer and death deed for a house, for example, while you're thinking about maybe adding somebody onto the title to avoid medical assistance, forced sales, for example. So it could be that you use some right away and then convert to a different document later. Alrighty, let's go to the next slide. Okay, I'm going to try to slow down because I feel like I'm going a little bit too fast. So while I say everybody should do estate planning, it's especially important if you fall into any of these situations on the slide. For example, if you're unmarried, you definitely want to do some planning because if you die and you have a partner, there's nothing that says that that partner is going to get your estate. So you have to have a legal document in place to make sure that person gets it. For example, a will work. You can name them as beneficiaries on items. If you have no close family or you don't want your family to control what happens, you definitely want to have a document that says who you want to control. If you're in a second marriage and you have adult children from a different marriage, you definitely want to have something in writing because that's set up for a fight because you've got the first family versus the second family that may be battling over the estate. If you receive a diagnosis, you want to recheck your documents to see if some things have changed about your wishes. And then, of course, if you want something different than the standard, everybody gets things equally, then you will want to do some planning. For example, if you want to give some of your estate to charity, you want to have a will or some other document that satisfies that. Or if you want to give things unequally, you want to do that as well. All right, let's go to the next slide. Okay, so who makes a good candidate to step into your shoes for these legal documents? Well, you want somebody who cares, and you can kind of gauge that by who comes to see you if you're in trouble, if you're in the hospital. Those folks care. So they might be good, but don't stop there. You want to see if they're trustworthy because some of these roles have fiduciary duty and they have a duty to your estate. And you want somebody who is not going to self-deal or do things wrong on purpose. You want somebody who's willing. That's a big one because a lot of people don't want to do the role of a personal representative in a will, for example, because it is a big responsibility. So you want to find out if they're willing to do that. They should be able to act. Some people have different strengths, circumstances. and they do not have to live near you to take on any of these roles. So keep those criteria in mind as we're going through the legal documents to see who would make a good person to have the authority that that legal document confers to them. All right, let's go to the next slide. So how do you do advanced planning? First of all, you do legal documents, but legal documents are better if you communicate to your people about them. So if, for example, you do a will, you want to tell your family that you have a will. I see a lot of my colleagues on our elder law listserv for the Minnesota State Bar Association. They're always looking for the will of somebody who's passed. So communicating to your family members that you have a will and where it is a good way to ensure that it's followed. You can also file that with the court, probate court, ahead of time. But certainly communication about, hey, we've got these legal documents and here they are when the time comes is important. Do not file your important documents away in a safety deposit box because there's going to be a delay in trying to get that open and a cost to get that open. So keep them with your important papers at home. You can file them with certain custodians like the probate court, and we'll talk about that more later. Okay, let's go to the next slide. And you don't need an attorney all the time to do these documents. You don't technically need an attorney to draft a will. You don't technically need one to draft a trust. All the beneficiary designations, you don't need an attorney. Those are easy. The trust, I would recommend not doing on your own, because to be a good trust, it should not be a boilerplate trust that you get from somebody. Don't even go to those. Well, you can go to them, but don't do the trusts of those places that send you a postcard to come have a free lunch or something. They usually use a boilerplate trust, and you want to make sure that you have a trust that is custom made to your circumstances, to your goals and circumstances. So you don't want to just get an old run-of-the-mill boilerplate that's not going to do what you want it to do. And it's going to cost you about the same amount of money as drafting a will anyway. So you want to have it done well. So I would recommend going to a private attorney in your local area, because they know the local probate court, what they require. They know the local rules, statutes, and what's needed. So that's my 2 cents on that. Wills, you could get by doing it on your own, but you should have somebody review it just to make sure that it satisfies what you need for a valid will. And I recommend going to an attorney for that, because there are certain things you could put in a will that makes it more protected from a contested family member who wants to fight about it. So go to an attorney for a will or a trust if you can. But for the other things, you don't need an attorney. All right, let's go to the next slide. Just to recap, there are documents that are used during your life, such as controlling your body, a healthcare directive, and a POST, also known as a provider order for life-sustaining treatment. That's a traveling doctor's order about what kind of treatment you prefer when you're outside of the hospital. So at home, for example. Those are the things you put on usually the front of the refrigerator for the EMTs to follow. Then for your property and finances and private information, you have power of attorney and trust. And trust straddles both during your lifetime and death, depending on what kind of trust you have. Let's go to the next slide, which you can guess already is what covers things after your life, which is healthcare directives if you have funeral and body donation, organ donation information in it. Trusts, again, wills, and beneficiary forms. So let's go to the next slide. And now we're going to look at some legal documents. So now go to the next slide, please. Okay, first, well, I lied. We're gonna have one more slide. So I just have a slide here about some of the advantages and disadvantages of the three main documents that cover you after you passed away. So you have a will, trust, and beneficiary designation. So beneficiary designations we're going to cover first. Those are easy. The main advantage of those are ease, and it avoids probate. And you can change it anytime very easily by going to the whoever holds the title to that particular asset, like the bank. They've got a particular form. You just go there and ask for the form, and you change the beneficiary and give it to them. The disadvantage to a beneficiary is that it does not protect it from a forced sale for medical assistance. So what the heck is a forced sale for medical assistance? So when you're alive and you are applying for medical assistance to pay for long-term care, this is long-term care services. So things where you need services of some sort, either in your home or in a nursing home. And the county uses the program medical assistance to pay for a portion of that care, and you contribute some of your income towards that cost as well. When you apply for that program medical assistance, the county asks what you own. And when you name a beneficiary on an asset, you don't give it away, you still own it. So it's still available to you. So it's going to be counted. So if your accountable assets are too high to be eligible for medical assistance, they're going to ask you to spend down some of those assets to get to the eligibility limit. So you can pick and choose which asset you can liquidate and spend down, but sometimes you don't have a choice, and you only have, for example, if sometimes you've named transfer on death beneficiary on your house. You might have to sell the house to become eligible if you're not living there anymore. So that's a big disadvantage, is medical assistance problem. For a trust, the advantage is that it's very good at having instructions about what you want to be done with your assets. The big advantage is that it avoids probate. And so there's more privacy that way. Whenever you go through probate, the court is going to be ushering your estate through paying debts through distribution. So there's going to be there's going to be a lack of privacy. They're going to see what your estate is and where it goes. And some people don't want that. So trusts are good at avoiding privacy. Avoiding not being private. The big disadvantage of it, though, is it's expensive. It's going to cost about the same as a probate. And if it's a really tricky trust to draft, it's going to be more expensive. And there's lots of different trusts out there in the world. For our purposes, the most common trust that people do to avoid probate is called a living trust. That's where you make it during your lifetime, and you then transfer your asset into the name of that trust. So the trust owns it, and the trust has a trustee, which is typically you. So you get to control it during your lifetime. This is good because you can decide to sell it easily, do it more easily. You can transfer it back into your name so you get more proceeds, whatever the case may be. You've got control of those assets. There are other trusts where it's irrevocable, where once you put your assets into the trust's name, you can't take them out again. Usually the folks that do those have a large estate, and they're doing it for more tax purposes. And it's not something that most people do. Most people do the living trust, also known as a revocable trust, so you can take things in and out. The disadvantage for a revocable or living trust is that because you have that control, your assets are available, and the medical assistance program is not. The medical assistance program says it's still available, and they'll count those assets. And then you might have to spend them down. So it doesn't protect it from a forced sale if you're over asset for medical assistance. And also, it could cause ineligibility because you've given a gift to the trust. So you might have to give it back to yourself to undo that gift. So that's a disadvantage for folks. But trust can be good. I'm not trying to dissuade people from doing trust. I just wanted you to know the big disadvantages. And wills, of course, they are good because you can have lots of instructions, especially about real estate. Sometimes people want to, for example, they have a child that maybe takes care of the house more, or it's a farm and they want the farmer child to have first crack at the house if they want it. And if they don't want to live there, then an instruction could be that it's sold and the proceeds divided. Whatever the case may be, you can have more instructions about things. It's really good to have a will because you can have a tangible personal property list. This is the thing where you can say who gets the grandfather clock, who gets the dishes, whatever the tangible personal belongings. If they're special ones, you can say who gets that. And with a will, you can just mention, I have or will have a tangible personal property list. And then later, you can do that list and attach it to the will without having to do a codicil or hold no will. So if you have that language in your will, it's very, very good and very easy to have that list. And sometimes when you have a will, it's not going to be used because you've named beneficiaries on your assets. So a will's not going to be needed, but that tangible personal property list is still in there. So your family can use that to distribute the personal belongings easier. So it's good to have a will, even if you plan on avoiding probate by doing other things, because it can be a safety net in case you come into an asset that kicks you above the limit where you need a probate. And you can change it, of course, anytime before you die. You can file it with the probate court and it's sealed so nobody sees it until you've passed away. It's a good place to keep it so nobody has to look around for it. And you can find it as well. The disadvantages of a will is does not avoid probate. That's a big one. So if it's going to be used to pay bills, distribute your assets, it's got to go through probate to do it. Another one, it can be contested, and it can take longer if it's contested. But on the other hand, you can put language in there that makes it very hard to contest. If you don't keep it safe, it can be lost. It's as expensive as a trust usually, unless you do it yourself, if you have a simple estate. We do draft estates for, we do draft wills for people with smaller estates. So we're just starting getting into that. So we can perhaps do that for folks. A will does not protect your assets during your lifetime for those forced sale or eligibility purposes because a will doesn't affect any of your assets until you've passed away. And I know there was a question about, do all wills go into probate? If it's going to be used officially to distribute the estate, it has to go through probate. But like I said, sometimes you have a will, but you've done some other planning where your assets go automatically to your beneficiary, for example. Your probate estate might be small enough where a will is not going to be needed. So in that case, a will is not going to be used unless it's got some useful thing in it, like the tangible personal property list, which makes it easy for the family to informally distribute things. So what's the amount of the probate estate that kicks it in probate. So if you have titled personal property in your name, that doesn't go to anybody automatically. If it's $75,000 or more, that needs to go, that those assets are part of your probate estate, and that probate estate needs to go through probate court to go to the heirs. If you own real estate in your name only that does not have beneficiary, that needs to go through probate. So it's real estate in your name only with no beneficiary, and titled personal property worth a total of $75,000 or more. So if you can add beneficiaries to things, you can take, for example, if you had a bank account and you name a beneficiary in your bank account, that puts that bank account in your non-probate state. So then if you just move things into your non-probate pile, you can get to the point where if you die, a probate is not going to be needed because those assets in the non-probate pile all went automatically to your beneficiaries. And then if there's only just one, like a few cars that are in your name only without beneficiaries and they total $50,000, and then you forgot about a bank account that ticks you over 75,000, then that would have to go through probate. But otherwise, if you've got like $50,000 and a couple of cars, 3 cars or something, you can do a paper way of distributing it, and it's called an affidavit of collection of personal property. The DMV has a different title, but it's the same concept. It's just you wait 30 days. Your heirs wait 30 days, and then they fill out this affidavit saying there's no probate going to be needed. I am a successor in interest, and they give it to whoever the title holder is, which is the DMV, and then it gets put in their name. So easy peasy. So let's go to the next slide. Good questions, by the way. Alrighty, so let's talk about some more of the beneficiary forms. So we've talked about the bank one a lot, the payable on death form, the POD, but there's the same thing in the transferable on death form, but that's for stock in vehicles. So if you have stock, if you went to them and say, I want a payable on death form, they're going to know what you mean, but it's technically transferable on death form. The DMV has a form, and I've got it in some following slides. If you Google vehicle beneficiary and the form number, you'll be able to get to it on the Driver Vehicle Services website. But the other big one is the transfer on death deed, and that's used for real estate. So this is a relatively new way of adding beneficiaries to a home, and it's been around for, gosh, I want to say close to 10 years now, but still relatively new. So it's a way, if you have a small estate, like a couple of bank accounts, cars, and then a house, you can avoid probate by doing beneficiary, by doing a transfer on death deed. So the whole point of doing a beneficiary, like I keep on saying, is to avoid probate and like keeping it out of your probate estate. So let's go to the next slide. Okay, so this is the first page of the transfer and death deed for real estate. So you can see that question, are these forms necessary if I have everything in the living trust? Good question, Jake. It's not necessary. But if you wanted something to go a different route, you could still do these forms, but it's not necessary because the living trust, if your living trust has the house in its name, that would do the same thing. So transfer and death deed is 2 pages, and this is the first page of the one that you can get from the Minnesota Department of Commerce. This is the one that attorneys use, and anybody can use them. You can go to the Department of Commerce's website and get them. I have the link later on in the slide. And you can see it's Form 10.8.1, but this is for an unmarried grantor owner. They have one for married grantors too. So a little bit of explanation of the form. You can see you got to have a date on there. You are the grantor. If you own the house and you want to name a beneficiary, you list your name on there. You can either do your full name or middle initial, just your middle initial there. And then you say who your beneficiaries are. Oh, Karen says that the Itasca County Assessor's Office will help you do these. That's wonderful. I did not know that. So good information there. So, and also we will draft these for folks too. So naming beneficiaries, you have some options here. You can have more than one beneficiary, but the language is important. What you put here for beneficiaries, if you don't have it clear that there's some of what happens if the beneficiary dies, where does that beneficiary's interest go? It can kick it back into probate. So it's important to, if you want to avoid probate and you have more than one beneficiary, you want to have survivorship language in there for those beneficiaries. So it would say something like, not on this part, but maybe on an addendum to the deed, it would say something like, if one beneficiary dies before the grantor's, that beneficiary's interest goes to the surviving beneficiaries equally, or something like that. If it doesn't have survivorship interest, that deceased beneficiary's interest is going to go through probate. So kind of defeats the purpose. So that's why it's good to go to an attorney if you're going to have more than one beneficiary. If it's one beneficiary, easy. Just put one name. And then the legal description, you have to use the legal description that's on the current deed. Don't use the property tax market value because that sometimes is abbreviated. So go get the current deed. If you don't have it, you can often find it at the county recorder's office. They make a copy for you. And then you can check if it's Torrance property or not. You'll know it if it is. It's either Torrance or abstract. Torrance is going to have a certificate of title. Abstract is not. Is it abstract? And then I would recommend checking the box that says it conveys interest that you have before this document and after this document, just so that everything gets to your beneficiary. And then there's a new thing on the bottom here that says warning to grantor owner. This is just a notice that says, hey, the owner probably has homeowners insurance, and owner, if you want that to continue for 30 days, tell your homeowners insurance. So that's a nice thing. If you want it to continue, you got to tell your homeowners insurance. Next slide. This is the second page. And then on the top, it says to the beneficiary, it just says, hey, there could be homeowners insurance on here. So go check it out. But it's only going to last 30 days. So that's a new thing. So be careful if you're going to use a transfer on death deed that you don't get from the Minnesota Department of Commerce conveyancing blanks website. Some of the old forms might be floating around and you want to use the newest one, and it's got to have that language. And then you sign it in front of a notary. And then on the bottom it says this instrument was drafted by. You have to put whoever fill it in there, because otherwise it's not going to be recordable. And you want it to be recordable, because if you don't record it before you die, it's not effective. And that's all there is to a transfer on death deed. Pretty easy. It cut off the bottom, but there's nothing consequential on the bottom. Let's go to the next slide. Oh, I already talked about it. Make a copy for yourself and your beneficiaries and go record it. Not effective if you don't record it. All right, next slide. All right, so vehicles, another asset that people commonly have are vehicles. And there's a way now to name beneficiaries on them. So it's the form PS 2004-2. It's really tricky to find on their website. So Google vehicle beneficiary form PS 2004-2 Minnesota, and you should find it, or Minnesota Driver Vehicle Services. And it should pop up to their website that has a list of title forms. So this allows you to name one beneficiary on it, though. So if you wanted more than one person to get it, then maybe this isn't the best option. And you got to file it with the DVS office. And then keep a copy for yourself, and you could give one to the beneficiary as well. Alrighty, go to the next slide and you can take a look at it. So I put both pages on one slide, and I apologize if it's really hard to see, but we don't need to go over it much. All owners have to fill that out, but one owner signs it. If you're married, you gotta get the spousal consent. If it only has one spot for one owner to sign. So, for example, if me and my husband were going to name a beneficiary, I would sign as the signature of the owner, and then my husband could sign signature of the spouse on the spousal consent section. And then there's some acknowledgements on the section F. It's just some basic things you can see. But the nice thing is it's avoids probate. And you sign it in front of notary. And that's all there is to a vehicle beneficiary form. All right, let's go to the next slide. I'm keeping track of the time so we don't get too late. And we're doing good, because now we're at the traditional testamentary documents, wills and trusts. And like we talked about before, it tells where your estate goes after your death. If it needs to go through probate, it tells the court and your personal representative how to distribute after all the debts and claims are paid. If it's a trust, it hopefully will go automatically, so no probate is needed. Sometimes people forget to fund the trust with every asset, so it's good to have a will and have a language in there that says if the trust didn't cover everything, this is a pour over clause. The assets should go into the trust, pour into the trust, and the trust handle it. So the instructions of the trust would be followed, but you lost the privacy part of it if you don't have all the assets into the trust before you die. And probate would be needed. So again, boilerplate, sometimes good, as you could see from the beneficiary forms. That's all boilerplate. That's okay. For wills and trusts, a boilerplate isn't always good. And I'm not going to talk about other types of trusts that people have, such as supplemental needs trusts, special needs trusts, those type of things, because it's too complicated for our time now. So we're going to stick to the typical trust for estate planning, which is what we talked about, revocable trusts, such as living trust. Alrighty, let's go to the next slide. So what makes a good will, a valid will? So you want to have it typed, no handwriting. Minnesota doesn't like handwritten wills, also called holographic wills. You have to type it. You have to be 18 You have to know what your estate is and have a sound mind and know what you want to happen with your estate. A lot of people think you have to have a whole bunch of stuff to have a valid will, but it's not, you don't have, it's really minimal. All you have to do is you have to sign your will in front of two witnesses who then also sign. And that's all there is to it. You don't even have to have it notarized. But I'm sure you've seen wills before. They typically all are notarized. And it's good to be notarized, but it's not technically required. Also, you can put in lots of different language that will make sure your wishes are followed, especially if there's a fight. For example, on the end of a will, if you want to stop a fight in its track, you want to have what's called the self-proved paragraph, which basically is a paragraph of specific language that says, I'm the testator, which is you, is of sound mind, and there's no reason that the court should think this is not a valid will. I'm not going to do it verbatim, but that's the gist of it. And then that's signed as well. And there's other things you can put in there, which is good, like a tangible personal property list. To me, that's worth doing a will right there. You can change a will up until the point of your death if you have sound mind to do so. Another good thing, though, is to safeguard it from fraud by at the bottom of each page. You want to have a spot that says last will and testament of blank and have your name typed underneath it, and then you can sign that blank. And each page have a number system where it says page number 1 of 6 or whatever the case may be. That way it makes it hard for people to slip in a forgery because it's gonna be hard to do the numbers right and to get your signature right. Those signatures do not need notarizations. That's just extra safeguards, not technically required, but it makes it a better will. Alrighty, let's go to the next slide. Oh, I forgot to say. So a lot of people come to me and say, well, can I do a will I find online? And the answer is you might be able to. If the will has the things that Minnesota needs to be valid, which we just heard are not much, it could be used. You just have to have a spot where you sign and the two witnesses sign. And it says where your stuff goes. This slide here talks about what is generally put into a better will. So these are the things that a will could probably have if you wanted to do everything without the court or the person represented getting confused. But you don't need everything. So I just took the different sections of a will and put them on here. Of course, always have the opening where you identify yourself, Kristin Parendo, testator. I revoke all prior wills, that sort of thing. The next one says to the person represented that they have to pay debts and taxes first. So this gets to some of the duties of the person representative. And this is important to know because a lot of my clients who are the adult children of somebody who dies, they come and ask, what am I supposed to do? And we talk about their duties. And one of the duties is to safeguard the estate so that the debts and claims are paid properly. And I have a slide on it. So I don't know exactly where the slide is, but maybe we can jump ahead and I can show you. Linnell, would you mind jumping ahead? Go ahead and one more. Yeah. So, yep, back one. Yeah, back one more. Should be one more. the one before this one. Yeah, this is one. Thank you, Linnell. So this is the statute that says how things, whoops, go back to the other one. It says how things are supposed to be paid before anybody gets anything. So you'll see in a moment when Linnell gets to the slide. Go forward, Linnell. Yes, there we go. So the personal representative is often going to be faced with family members that say, hey, I want to have this asset, or I want to take the car, or I want money. But the PR has to be strong to say, no, nothing, nobody's getting anything. And the personal representative has to be strong enough to say, I'm not going to pay anything until I know what bills there are. So I know what order and what amount to pay. And I saw that the question, is there a pamphlet that talks about PR duties? I don't know if there's a pamphlet, but the Minnesota Attorney General's office has some probate materials that talk about it. We have some on the Minnesota Law Help site that has a will question and answers, but there isn't one that's specifically just about personal representative duties. That's a good idea, though. Maybe we might make one. So the personal representative has to first say, what is the scope of the deceased estate? Because they got to figure out what the person owned at the time of death. And they also have to figure out what did they owe for debts and what other claims might there be out there. Because debts and claims are different things. Claims could be something like a medical assistance claim. Because medical assistance, if you get medical assistance for long-term care after the age of 55, there's going to be a medical assistance claim. And they're going to say, well, if there's real estate, we're going to put a lien on it. They'll take it that way. But if there's more that has to be paid, they can also do it a probate claim. And the medical assistance comes under number 4. So after any administration costs, funeral expenses, federal taxes are paid, medical assistance is going to get paid. And that often can eat up the whole estate, depending on what the claim could be. So the personal representative has to be careful not to give anybody anything until all these things are paid in the right order. And then you get to number 7, that's everything else they might owe. Like if they might owe somebody a personal loan, or there's like a phone bill or something like that. Everybody on that last level, if there's anything left, they get a prorated share. And then if there's, if you're doing a prorated share, there's not going to be any money to distribute. But if you get to 7 and everybody gets paid their full amount and there's still something left over, that's when it goes to the heirs, the dividees. So let's go back to that slide that talked about the section of the will. And I know we got 4 minutes left, but we're almost done. We're doing it. Here we go. So you got to pay debts and taxes and claims. I should have put claims on there. And then your will is going to have, if you have specific gifts, like if you want the house to go to a specific person, or if you have charity that you want to get certain things, and you can also have that personal property list. After those special gifts are given, everything left is the residue of the estate. And then there's going to be a provision that says how that residue is distributed. It's usually distributed equally. People do it equally. If you do things equally, you technically don't need a will because the statute says that anyway. But it's good to have a will because you can have the tangible personal property list. And you can do things unequally. What about if you have co-signed on your child's student loans? That could be a debt that's unpaid, but if your child is still making payments on it, it's probably okay. It's up to that creditor to make a claim, and they might wait too long to make a claim. So sometimes what a state will do is wait for that time period to go. And don't ask me time period because there's a few different ones and I don't want to mess it up. So, and I don't do probate on a regular basis, so I don't feel comfortable telling you the deadline. But it's like 1 year, 2 years, something like that. But the date for medical assistance, that claim had no end date. It's good. Well, it's good forever, but the medical assistance lien is 1 year. All right, getting back to the residue, that's where everything else is divided however you want it to be divided. Then there's a provision about who you nominated as the person representative. If you don't have anybody, there's a statute that the court will use to find somebody. And then 6 is just definitions, various things like that. If you have minor kids, you want to put in conservatorship, guardianship clauses, and then you sign, kind of 2 witnesses who also sign, and then maybe the self-proved language. Is there any way to get a printout of the slides? Good question. Brenda can answer that at the end. I'm happy to provide them to Brenda, but I think they'll have them available. Let's go to the next slide. And we have 1 minute left. File it with the county courthouse, keep a copy. Don't lose it. You want to review it over time. Let's go to the next slide. We covered this one. Let's go to the next one. Brenda says I'll send them out with the recording. And then we're done because I've just got links to different legal documents. We didn't cover healthcare directives, but there's links where you can get those. Let's go to the next slide. And you can get power of attorney forms, transfer and death deed form. Let's go to the next one. And I didn't put any forms for wills because boilerplate's not good, but you can find wills online. If you qualify for our services, I'd be happy to review any will that you might do on your own. If you are qualified for us to do a will for you, we'd be happy to do that as well. You can find me at those contact information spots, and you can find Justice North on our website and all those social media platforms. And the next slide, or maybe that's it. Oh, also thanks to Brenda and Arrowhead Area Agency, and to our funders that help us do these things, the Minnesota Board on Aging and the Arrowhead Area Agency on Aging and the Older Americans Act. And now we're done. 11:01.
Thank you so much, Kristin. We so greatly appreciate your valuable insights and sharing those with us today. And your expertise in legal planning really provides all of us with at least a jumping off point, because there's so much depth to this. And so I appreciate it. But it's really great information that we can all use both in our own individual lives and our work. So I just want to say thank you to our attendees. We're grateful for you, for your time and your engagement today, and your thoughtful questions and active participation really makes our sessions even that much more valuable. And we appreciate, we know how precious your time is, and we don't take it lightly that you choose to spend that time with us. So I'm just going to close out since we're over time and we've gone through everything prior to, just to remind you that we've got other sessions coming up and the ways to connect with us out on Facebook and on our website and things like that. And we look forward to seeing you all next month. And we wish you the best with the upcoming holidays, and we'll see you next month. Thank you so much.
Thank you, everyone.